Well, it was a big day at the Supreme Court on Thursday, with the justices hearing a challenge to a combination of cases involving two major issues facing the country: birthright citizenship and nationwide injunctions from federal district court judges. Are the children born here to illegal immigrant parents U.S. citizens under the 14th Amendment? And do federal district court judges have the constitutional authority to stop presidential action on the spot? In other words, the first question is probably the more consequential one, but for now, it's just the vehicle, at least for this particular stop at the Supreme Court. The Trump administration's appeal asked only to consider that second question: on what authority are these district court judges intervening to stop everything they don't like? I've talked about the birthright citizenship issue at length. I'll link my latest video on the topic from January. I think the case that it's a fundamentally wrong understanding of the 14th Amendment is very strong, but that question will have to wait until another day, maybe next term at the Supreme Court, because today was all about the courts themselves. If you haven't followed closely in recent months, judicial interventions against Trump policies have reached record pace, and a particular type of judicial intervention. Federal district court judges have issued some 40 nationwide injunctions on policies ranging from this birthright citizenship one, Trump issued an executive order attempting to undo it in February, to expedited deportation under the Alien Enemies Act, to the banning of transgender people in the military. And the controversy and the legal question here isn't about the blocking of policy per se. The Supreme Court itself intervenes to block unconstitutional policy all the time. See the Biden-era vaccine mandate, or the eviction moratorium, or the bump stock ban that both Trump and Biden pursued. The questions are blocked how and by whom? Because these nationwide injunctions from district court judges have complicating factors that interventions from the Supreme Court itself do not have. One, district courts have limited jurisdiction. They cover a district. There are 94 of them across the country, not the whole country. And two, these are national policy decisions, even if they are temporary, made on the spot by these judges. They are presumptions about unconstitutionality or illegality, without the full process to evaluate that case. So, do district court judges have the authority to issue nationwide policy blocks on snap judgments or not? That is the question the Trump administration brought to the Supreme Court on Thursday. And of course, there were the formalities and traditions. Sotomayor interrupting everybody to grandstand about birthright citizenship, even though that's not the point of this hearing, and Chief Justice Roberts telling her to shut up.
I'm sorry. Go ahead. Here, there's a discrete identified group on one issue. Even if your parents are here illegally, if you're born here, you're a citizen. And you are claiming that both the Supreme Court and no lower court can stop an executive from violating that holding.
We are not claiming that, because we're conceding that there could be an appropriate case.
Only a class, only
Can
by
I
a
hear
class.
Can I hear the rest of his answer?
Plus, Elena Kagan arguing with herself. Now, nationwide injunctions from district court judges are perfectly understandable, especially on such clear constitutional questions.
Let's assume that you lose in the lower courts pretty uniformly, as you have been losing. You're losing a bunch of cases, this guy over here, this woman over here. They'll have to be treated as citizens, but nobody else will. Why would you ever take this case to us?
Even though that unanimity is probably a direct result of what Kagan herself warned about under Biden. Judge shopping.
It just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through a normal process.
But to the issue, where does that supposed district court nationwide injunction authority come from? It is a little magical, or at least requires some imagination. Article 3 of the Constitution establishes the federal court system. The Supreme Court is the only constitutionally established federal court. All other federal courts, including the district courts, are established by Congress. So, did Congress ever authorize this power for district court judges? No. The power was just sort of assumed. And that is a primary argument against these nationwide injunctions. They're largely ahistorical and only appeared in recent decades. If this was the constitutional and congressional intent for the courts, Why wasn't this a function of the lower courts for most of our history?
When were the first universal injunctions used?
We believe that the best reading of that is what you said in Trump against Hawaii, which is that Wirtz in 1963 was really the first universal injunction.
So we survived until the 1960s without universal injunctions.
That's exactly correct. And in fact, those were very limited, very rare, even in the 1960s. It really exploded in 2007. The Ninth Circuit had started doing this in a whole bunch of cases involving environmental claims.
Even Congress's structure for the district court system implies limited jurisdiction. Why are district court judges confined to a district if their jurisdiction is supposed to be national? Why don't we just have hundreds of national judges who set up offices wherever they want? It's because their jurisdiction was intended only for a particular area. There is no other reason to organize that way. Limited jurisdiction is also implied by the way courts accept and hear cases. Whoever brings the lawsuit has to prove standing, a direct stake in the matter, a direct harm suffered, or one that will be imminently suffered. If it takes particulars to bring the case, then it makes sense that the remedy would also be particular to the person or people who brought the suit too. And we know this is convenience rather than law or philosophy, because the arguments in favor of these district court nationwide injunctions, at least the arguments presented Thursday, are practical. Well, come on, we have to do it, because not doing it would just be complicated and messy. What are we going to do? Have hundreds or thousands of individual lawsuits?
Does every single person that is affected by this EO have to bring their own suit? How long does it take? How do we get to the result that there is a single rule of citizenship?
Well, one, that's not a silly hypothetical. That's how it was done historically. Thousands of people had injunctions against FDR.
I would draw an analogy to the New Deal, that actually there were very, very passionate challenges to sort of nationwide policies during the Roosevelt administration, and they were not addressed by issuing universal injunctions. He cites an example where in one case, a policy had been held illegal, and there were like 1,600 injunctions against that policy, all protecting the individual plaintiffs.
And two, we do have class action lawsuits, Those people can join together and form a class and get injunctions across districts or even nationwide. And yes, there are rules for what counts as a class, and there is a process to qualify. And yeah, that is a hurdle, but the alternative is just a guy and a judge determining national policy, at least for the moment, based on what they feel like, not based on any actual process.
There are 680 district court judges, and they are dedicated and they are scholarly, and I'm not impugning their motives in any way, but sometimes they're wrong. All Article 3 judges are vulnerable to an occupational disease, which is the disease of thinking that I am right and I can do whatever I want.
And if we believe in district court nationwide injunctions because they're supposedly a constitutional check on power, we might want to think again, because at least in the moment of issuing that injunction, nobody checks that single judge. In that move, he is even more individually powerful than the appellate court judges or the Supreme Court justices, because the district court judge doesn't even have other judges on the panel to challenge him.
Now, on a multi-member appellate court, that is restrained by one's colleagues. But the trial judge sitting in the trial judge's courtroom is the monarch of that realm.
So in sudden 2A enthusiast Sonia Sotomayor is now warning you, careful, without these district court nationwide injunctions, the next president is coming to take your guns, because there won't be anything to stop him.
So when a new president orders that because there's so much gun violence going on in the country, I have the right to take away the guns from everyone, we and the courts have to sit back and wait until every named plaintiff or every plaintiff whose gun is taken comes into court.
You don't have to worry about the scaremongering from this concerned gunslinger, because one, anyone whose guns he takes in that way can still file suit and can still get an injunction, and so can a class if he does that to many people. Two, the Supreme Court itself, led by Stay Strapped Sonia, can intervene anytime they want with a nationwide ruling. But three, this sword is double-edged, because for every wise or legally square exercise of district court nationwide injunctions, there's at least one that's totally wrong. bad policy made on the spot, and worse than when the president or Congress does it, it's coming from someone who's not even politically accountable to the people. If a president or Congress go rogue, the people can vote them out in a few years. If a federal judge starts freestyling, he's insulated. Yeah, Congress can impeach him, but that's a difficult burden to clear. Or if you believe the John Roberts philosophy on the matter, for mere policy disagreement, even impeachment isn't an available or appropriate remedy. It's just take that guy's crap until he withers and dies on the bench, or until he decides on his own terms that it's time to go. And that's the irony with this district court nationwide injunction defense. It's supposedly in the interest of speed. Oh, we have a big problem, so we need to fix it quickly. Yeah, raw judicial power might be a quick fix until it becomes an unaccountable problem, in which case the problem lingers a lot longer. But that is what effective propaganda does. It doesn't just confuse you. It convinces you of the opposite. Up is down and black is white, actually. Speed and quick fixes are not the point of our federal government anyway. Slow and steady is. Oh, how messy and confusing and time-consuming it would be if it was policy A here and policy B over there.
They come into our state, they need benefits. We have to do citizenship verifications, which is a burden for us. They say, okay, maybe their citizenship turns on when they enter New Jersey. We've never in this country's history since the Civil War had your citizenship turn on when you cross state lines.
Yeah, or that's the point. District Court A will find X, and District Court B will find Y, and the cases will get appealed to the appellate courts and the Supreme Court, and the matter will get resolved. And that system is designed to minimize the scale and the reach of mistakes and abuses by unelected people in D.C. who think that they should have control of people who live thousands of miles away from them.
The appropriate way to do it is for there to be multiple lower courts considering it, the appropriate percolation that flows to the lower courts, and then ultimately this court decides the merits in a nationwide binding precedent. You have a complete inversion of that through the nationwide injunctions or the district
So, General
courts.
Sauer, are you really going to answer Justice Kagan by saying there's no way to do this expeditiously?
Yes, ma'am. The Trump lawyer tried to qualify and soften and explain away, but yeah, lower court judges are not supposed to have expeditious power nationwide, not constitutionally, where no such power is described, and not statutorily, where Congress gave them no such power either. If you want judicial expediency, that's your job on the Supreme Court. You want fast work? Then work faster, Amy. And speaking of Amy's questioning, the outcome in this case is pretty tough to predict. Alito and Thomas seemed solidly in favor of limiting this nationwide injunction power. Probably Kavanaugh, too, with questions that implied class action suits are the solution. As you'd expect, Kagan, Sotomayor, and Jackson all seemed pretty clearly in favor of this nationwide injunction power. So that's 3 confidently in favor, 3 confidently opposed. Gorsuch questioned both sides pretty toughly in this case, but he's been critical of nationwide injunctions in other cases recently. Roberts didn't tip much other than telling Sonia to shut up. But he did say if speed is necessary, well, the Supreme Court itself can act speedily whenever they want to.
This court can issue a decision and it will bind everything else. Is there any reason in this particular litigation that we would be unable to act expeditiously?
Absolutely not, Mr. Chief Justice.
Okay, thank you.
So maybe 5-3 in favor of limiting some judicial power here, but 2 of those 5 are far from clear. And then there's Amy, who's sounding a lot like a hobbit with a ring. I don't know. I kind of like this power.
After all, why not? Why shouldn't I keep it?
Amy Baggins aside, I'd say the odds are in favor of some limitation on these lower court judges issuing these blocks. Maybe just to their district or circuit, or just to the parties bringing the suit, or some combination of both. But the real legal answer here is, of course, the impossible. For Congress to do its job. If Congress intends for these district court judges to have this power, they should clarify. If Congress does not intend for these district court judges to have this power, they should clarify, since they're the ones with the constitutional authority here. The problem is Congress only intends to sit on one hand and point a finger of blame at somebody else with the other, agreeing to vote only when it's right about time for a pay raise. So until that gets resolved, we'll be stuck with some version of the same problem. Judges deciding how powerful judges should be and calling that a check on power. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on X. That is at ML Christiansen. You're always welcome to coming out and chatting my live streams as live on Wednesday and Sunday nights. Looking forward to it. Come on. Hey, if you made it all the way to the end of the video, that means you probably found some value in the video. If you found some value in the video, please consider supporting my material. You can do that one time or recurring for as little as $1 a month. It not only helps me sustain, but it helps me pay the people who make my videos possible. Linked in the description for you, mattchristiansenmedia.com/support. Thanks for listening.